Technology has changed the way we perceive life. Innovative and disruptive entrepreneurs rapidly scale their businesses by deploying modern technologies. Over the past few years, you would agree with me that the technology sector has bloomed rapidly, giving rise to unicorns like Uber, Airbnb, Twitter, Meta, Tesla, Flutter, Wave, Into Switch, Jumia, Andela, Piggyverse, Opay, you name the rest. From the rise of streaming services to the increasing sophistication of hardware, software, and virtual reality, the industry is constantly innovating, and Jackson Etienne is not left behind. At Jackson Etienne, our technology sector team has stayed ahead of the curve to provide ready solutions to our clients' business needs. From startups to unicorn, we have created a number of services that leverage on our sector knowledge and ensure that our clients are properly catered for. Also, with the rise of digital media platforms such as YouTube, Instagram, and Twitter, increased internet penetration, and the rollout of 4G and 5G networks, the media landscape in Nigeria is also rapidly evolving. These platforms have given Nigerian content creators a global audience, allowing them to showcase their talents and share their stories with the world. The media and entertainment sector moves at a rapid pace as well. As experts, legal advisors in this area, we did not just respond to constant legislative and case law changes, but actively engage to ensure that our clients are given the most robust and high-quality advice. We ensure that we provide solutions which are well-suited to our clients' needs. As co-sector head of the technology and entertainment sector and as a regulatory and governance specialist, I have helped and continue to help clients navigate the regulatory paths in doing business and maintaining their businesses in Nigeria. I have helped clients to also understand the importance of having good governance in their establishments. Good governance, as we all know, also helps clients to be able to raise capital, which is very important to innovators.
Good morning, distinguished panelists. Good morning, my amiable attendees. First of all, thank you everyone for joining us on today's webinar session. Today's webinar session is organized by the Technology, Media and Entertainment sector of the law firm of Jackson Etienne Edu. Jackson Etienne Edu is a full-service law firm with sector expertise. And why do we say we have sector expertise? So we have specialized and focused on specific sector areas and focused on having the industry knowledge to be able to advise our clients on the peculiarities regarding and bearing in mind the peculiarities that would affect their industries to enable us to deliver sound legal advice. So some of our sector areas of interest include the technology, media and entertainment sector, which has organized this webinar. We have the health and the pharmaceutical sector. We have the fast-moving consumer goods sector, the financial services sector, and the public sector. And also, as a full-service law firm, that means that we are a one-stop shop for all your practice all areas of legal needs. Our practice areas, some of our practice areas range from corporate commercial services, regulatory and compliance, data protection, intellectual property, commercialization of intellectual property, infrastructure, energy, labor and employment, banking and finance, corporate mergers and acquisitions, just to mention a few. Thank you so much, everyone, for joining in. And before I go to introduce my panelists, just to give a brief overview of why we are having this discussion today. It is a topical point as we look at navigating regulatory compliance in the Nigerian gaming industry. Some of us may be aware that a lot has been happening in that space from the Supreme Court judgment decision last year, reverting autonomy and recognizing autonomy of the state governments to determine and govern how sports betting operators, gaming operators would operate in the states as well, taking it away from the federation, and other activities that have been happening, ranging from more stringent measures in relation to anti-money laundering, anti-terrorism financing laws, anti-counterfeiting, even looking at financial aspects in relation to taxation, different compliance measures that come up, which is what my distinguished panelists will be doing justice to today. So that is going to be the bone of the discussion, and I want us all to please Be ready for an insightful session. My panelists are bringing a wealth of experience, a wealth of knowledge to the table. And then I think at this point, I'll just go ahead and introduce everyone and read their citation. I would like to start with Mrs. Adetun Adeyemi. Mrs. Adetun Juliana Adeyemi is the head of legal services and the secretary/legal advisor of the Lagos State Lotteries and Gaming Authority. As head of legal services, she's responsible for coordinating all legal matters concerning the Lagos State Local Lotteries and Gaming Authority, the LGA. She provides legal advisory services in her board, in the Gaming Authority. She ensures policy formulation, compliance, and corporate due diligence in the Lagos State gaming industry. Part of her responsibilities requires her to oversee the secretariats, oversee dispute resolution proceedings, manage communications from the LGA and industry stakeholders. This, of course, includes the Lagos State government, regulatory agencies, gaming licensees, and the general public. She is a lawyer with over 30 years experience. She has an LLB and she has a master's degree from the prestigious University of Ibadan. She's called to the Nigerian bar. She's a certified mediator and an associate of the Chartered Institute of Arbitrators, UK Nigeria branch. She's also a member of the International Masters in Gaming Law and International Association of Gaming Regulators. Adetun is a Christian, happily married with children, and she loves to spend her time empowering women and youths. Adetun, thank you so much for honoring our invitation. It's a pleasure to have you as a panelist. It's a pleasure to have you here. Thank you, ma'am. I'll go next to Mr. Jonathan Wanze. He is an adept finance tax professional and manager at Velet Advisory, which is a Pan-African professional services firm that provides financial and business advisory services to entities in the gaming, technology, and financial services sector. He has over 8 years of experience across West Africa, representing various clients in the gaming and fintech sector, with an in-depth knowledge of taxation, financial reporting, treasury management, and fintech solutions, which he had acquired even prior to joining Velet Advisory. In terms of advisory, he has held an integral position at one of the industry's most prominent fintech company, that is Capricorn Digital, where he worked extensively in the Nigerian financial industry, providing tax, audit compliance services, as well as advisory services. He holds a bachelor's degree in banking and finance from the Delta State University. He is a member of the Association of Chartered Certified Accountants and holds an advanced diploma in accounting and business. Thank you, Jonathan, for being a member of the panel. We are glad to have you here. Thank you so much. I'll move on now to Ms. Yeye Wida. Yeye Wida is a partner at the firm where she heads the regulatory compliance and governance practice. She's also the head of the technology, media, and entertainment sector, that is our host for this webinar. She oversees the firm's fintech practice group and holds a Harvard certification in fintech. She has over 17 years of experience advising clients across different industries on regulatory compliance, corporate governance, and commercial legal matters. She advises companies in the financial technology and digital services sector on licensing and compliance, with a focus on regulatory clarity, business continuity, and cross-border issues. Yeye regularly supports businesses, particularly those expanding into or operating in Nigeria, to navigate specific regulatory frameworks and maintain good corporate governance. She's a chartered secretary and a member of the Chartered Governance Institute of the UK. She also advises on competition law matters, including market conduct, regulatory obligations under the FCCPA, that is the Federal Competition and Consumer Protection Act. She has undertaken postgraduate research on abuse of dominance and pricing issues in Nigeria's regulated markets. I'll move on to Mrs. Tolu Olaloye. She is a partner at the firm and the lead for the sports and gaming subsector under the technology, media, and entertainment sector. Tolu is a strategic advisor in intellectual property, privacy and data protection, and an expert in cross-border compliance and digital risk, and a digital risk policy advocate. A highly experienced professional with over 14 years of experience in legal practice, particularly in IP law, regulatory matters, policy, data protection, privacy, and taxation. She has deep expertise in managing and protecting intellectual property portfolios across Africa, the Asia and Middle Eastern regions. She has knowledge of over 40 jurisdictions in Africa and is a trusted advisor in relation to dispute resolution, IP dispute resolution, data protection issues, regulatory matters, commercialization and enforcement. Across data privacy frameworks, the Nigeria Data Protection Act, the GDPR, the Guide for Implementation, the cross-border data flow protocols. She advises on data lifecycle, lawful processing, privacy impact assessments, regulatory compliance, data breach responses. Her advices are tailored and scalable data protection strategies aligned with local and international standards. Please, thank you so much, Mrs. Olayuri. Thank you, Tolu. Thank you, Yeye Wida. Thank you to all my distinguished panelists. It's a pleasure to have you, and we look forward to an engaging session. We know the wealth of knowledge that you are bringing and expertise into this conversation. And just to start off, just allow me to introduce myself. I'm Kodichi Aniborgo. I'm a senior associate in Jackson Etienne Edu, and I'm the deputy head of the technology, media, and entertainment sector. It is my pleasure to be moderating this panel session. And thank you so much to all our attendees, to our distinguished panelists for being here. And I think without wasting much time, we will get right into the meat of the matter. And I will reach out first to Tolu because, as we said, why are we here? We're looking at regulatory compliance in the Nigerian gaming industry, kind of starting us off on what the current realities are. Given the recent Supreme Court judgments, what practical compliance changes are operators facing in day-to-day operations? What has changed? What is new? What is currently happening in the Nigerian gaming industry?
Thank you. Good morning, everyone. Thank you very much for being here. I'm so excited to be here and grateful for giving us this opportunity at the TME sector. It's such an important conversation that we are having. When I think about Nigerian gaming sector, basically what stands out to me is how quickly it has grown and how fast the rules of the game are changing for many operators. And just to go into your question, Kodichi, the Supreme Court judgments changed the landscape of the lottery industry in different ways. Particularly in the operational running of sports betting and casinos. So operators in the lottery industry have had to deal with issues surrounding filings and reporting lines in two ways. First, by virtue of the judgments, lottery businesses and companies are now required to obtain licenses and permits from all states in which they operate. This is a compliance change operators. And they have to comply with all these licenses. Permits are integral in their operations. So the nature of these licenses and permits are very difficult to ascertain as a result of possible differences in requirement by various states and their frameworks. Secondly, only a handful of states have enacted lottery legislations, which leaves a compliance gap for lottery companies who have to operate in those states. Additionally, they also have the risk of having their businesses shut down in those states under anti-gambling laws and regulations. So when we look at it, the lottery operators also have to deal with delays in their compliance reporting obligations due to the multiplicity of framework from various states. So these delays are occasioned as a result of disparate framework among the states. Some states like Lagos, Oyo, Edo, Delta Rivers, Imo, Abia, Cross River, Benue State, Plateau, Kaduna, Niger states, they all have structured regulatory framework. And a host of states like Bayelsa, Akwa Ibom, Anambra, Enugu, Kogi, Nasarawa, Adamawa, and Sokoto have had ad hoc regulatory framework, and some others like Katsina, Jigawa, Bauchi, they have prohibited lottery activities, while the status of Kebbi, Zamfara, Kano, Gombe, Borno, and Ebonyi is undetermined at this moment. But this inconsistency in framework clauses, it basically causes undue delays in fulfilling compliance obligations. However, the most change being experienced by lottery operators based on the judgment is the complication and confusion in regulation. The National Assembly has introduced the Central Gaming Bill 2025, which is a piece of legislation to recentralize online gaming regulation with a different regulatory requirements, even though the Supreme Court was clear on the legislative limits of the National Assembly. Also, if we look at the Federation of States Gaming Regulations of Nigeria has introduced the Universal Reciprocity License. to centralize the process of licensing in the various states for its members. Though its sustainability is yet to be determined, and this arrangement, which has led to more issues in the federal state tug of war, is being amplified by federal financial crime agencies such as COMO, NFIU, requiring AML and CFT compliance. So all of which contributes to the uncertainty that makes the federal government's ease of doing business in Nigeria mandate, like it's something that's come to stay. So the law is saying that if you need to go to different states, you have to have your lottery registered in those places. Thank you very much, Coach.
Thank you. Thank you so much for that, Tolu. Thank you for introducing us and starting us off really on that. And also your mention of the central gaming bill, which I know that Lagos State's Lottery Gaming Authority and the FSGRN have had something to say on that. So I'll really be turning over to Adeto. Really, when we're talking about harmonization, we're talking about state policies and what is currently in place, given the decision of the Supreme Court and even what the states are coming to do as a federation. Can you really let us know how regulators are working towards harmonizing compliance thresholds, and even when we look at license fees across the different states? Should we have an expectation? Should operators be having that expectation, and investors looking into this booming industry, that regulators are looking to harmonize that, or they should expect fragmentation across the different states as the recent decision has enabled?
Yeah. Good morning, Cody, and all other members of this panel. I'm happy to be here. I'm happy to be part of this discussion, this robust discussion that has to do with the gaming industry in Nigeria. As regards the issue of harmonization, yes, the regulators are working decisively towards harmonization. This has been the objective of the state regulators even before the Supreme Court judgment. We have had this association even before the Supreme Court judgment. We've always been working together, trying to present a common front. And the only layback we had was that tussle between the federal and the states. And after the Supreme Court judgment, the states have come together stronger. And that's why they have introduced the universal reciprocity framework. And that universal reciprocity framework would cover licensing, compliance, enforcement, and all other areas of gaming in Nigeria. This framework is developed basically to streamline licensing requirements for operators conducting gaming in all the states who are interested in conducting gaming in multiple states of the Federation. And as regards licensing fees, while the universal reciprocity certification is on the way and it's at an advanced stage, it will be ready because we want all the states to be able to stabilize at state level. And there is this process to encourage states to ensure that they enact their laws in each state. We want each state to be able to have a working system. So these are all of the things that we're working on while we are working on the universal. And we have given ourselves a target as to when to fully commence on this. And once this comes to light, there will be one universal license, which once an operator gets this license, they will be able to operate in the states of member states, those members that are still within the federation. They can operate there with that universal license. And with that, they don't have to go to the states for other processes towards obtaining a license. And you will agree with me that this kind of coordination is not new. We have it in other countries, in other advanced technologies. So, and as a forward-looking regulator, we are also trying to mirror other countries and to make business easy for proposed investors. So as soon as this comes to light, we would ensure that operators don't have challenges of having to go to different states to obtain licenses. All the processes would have been done at the federation level. It would be like a one-stop shop where all their documents would have been assessed. And once it is cleared, they would now go on to operate in or as many states as they want to have. So, and like I said, we have it in America, Switzerland, even in South Africa. We have such where states regulate. Those gaming is regulated at state level, at county level, at province level, and there is always a coordination at the center to ensure that standards are the same. So we're also working at harmonizing the standards and every other aspects of the gaming sector. So I will want to say that operators should not brace up for fragmentation. They should be ready to work with a unified system where we would ensure that compliance is, is done from the center. We'll have a smooth and their business will go smoothly and everything will work and it will be a win-win situation because that is what the operators have always yearned for. And we are ready as regulators to make sure that we listen to them and make business easy for all the operators. Thank you.
Thank you so much, Adeto. I think that is comfort to investors' ears and operators' ears that the regulators across different states have always been interested in harmonization and even looking at the central repository that will be in place and just to boost that industry further and to encourage more investments and expected ROI. Adeto, I'm going to ask you further because you are the executive secretary for the Federation of State Gaming Regulators of Nigeria. So at this stance, we understand that there are 24 states that have come together on this. What is the position looking at the other 12 states that are yet to be a part of it? How can their non-participation affect this national regulatory cohesion? We're looking at Kano State now that has banned sports betting. We're looking at states that are yet to adopt this framework. How would that enable the FGRSN achieve and the URC be able to achieve what it is being set up for?
The Federation of State Gaming Regulator, like every association, it's a collaboratory voluntary platform. It's a platform that is encouraging states to adopt the URC framework. And the purpose is that we are interested in making sure that business is easy and smooth for operators. So we recognize that each state must move at their own pace based on their beliefs, their culture, their policies. So non-participation at this stage is not too much of a problem. There can only be disparities for a while. The not participating state of those states will not derail the view of the 24 states that are presently in the Federation. And our approach in the Federation is that of persuasion, inclusion. We are waiting for them as soon as it takes up and they begin to see the benefits. They would see the reason why. We want to demonstrate that by showing value for unity. Because when we are together, we are stronger as a group. And it makes life easy for the investors, both the present investors and the intending investors. So we intend to move on because we have a larger number. So we are not discouraged. Even at the Supreme Court during the matter, we had those states that were with us, we had those states that were not with us, we had those states that were sitting on the fence and did not belong to any of the parts. But we're not debarred because we know that we're doing the right thing. We know that that is what the Constitution says. So we are not debarred. We know that by the time we begin to show value, we begin to show what they are likely to gain by joining that organization, that association. So most of them will come back. And some of these things is that there will be harmonized regulatory regimes. There will be revenue efficiency. Will reduce the duplication of the processes for operators, and it will encourage and give confidence to investors, especially foreign investors, because this is a an industry where most of the investors are not from Nigeria. So we need to have a harmonized standard where even looking at the social media or anywhere, they would know what is obtainable. And so when they are coming in with so much confidence. And we are very intentional about this because that is the way to go. That is the future. That is the only way we can strengthen the industry. So for now, we are not so worried. We know because some of them who were not with us at that time are already coming in quietly and gently. And we are beginning to show them value for why we must have an harmonized standard in the industry. And we know that very soon we'll continue to engage them actively, begin to have meetings. We've had meetings with some of them. Some have come personally, especially to Lagos State Lotteries and Gaming Authority, to see what we do, to shadow us, to mirror us, to make us walk them through what we do and why we should stay together. So our vision, our mission is simple. We'll have a cohesive Nigerian gaming market that is built on harmonized licenses. We'll share experiences, share knowledge, and very soon, I'm sure we'll all be on board. And it will be a win-win. It will be good for all the stakeholders in the industry. Thank you.
Thank you, Adito. So what I'm hearing is from the effectiveness of the Universal Reciprocity Certification Framework, the others will be won over. When they see how well things are going, they will definitely come on board. That is really very good to hear. And then also looking at the different benefits that it will bring on board, even in terms of, reducing their cost in terms of registration requirements and all those, like just harmonizing that and that effect. So thank you for that. And I'll use that to actually now to reach out to Jonathan, because we're looking at, and what Adito has touched on, is encouraging of investments as well. So when we're looking now at the market and looking at operators coming into play, Jonathan, to what extent would you say that these compliance costs, rising compliance costs, are impacting the ability of smaller operators to be able to enter into the market, from your expert opinion?
Thank you very much. I'm really excited to be here. I think quite all right. I don't think there should be probably any issue with compliance costs, because brands actually have to focus more on their reputation. Also, again, the industry itself is a high-risk industry, and this industry has, in fact, a lot of implication on so many aspects of the economy. You're looking at there's a risk of money laundering, terrorism financing, all these are issues that could arise by virtue of failing to comply. So I don't think the cost itself should be the concern. I think it should be more of their reputation. How are they being perceived by the users, the customers that use their platform? It's very important that you spend more time in making a product out there and ensure that your users are confident to use it. So I don't think the cost really should be the main focus. What's the point of having a product? Also, again, it emphasis on smaller companies or smaller investors trying to come into the industry. It's what it takes. There are different markets and different market requirements, just like you have licensing in different countries. It's in fact, thinking even in Europe and other countries, they don't issue licenses just anyhow. Sometimes one license could be issued in 10 years. So you understand that these requirements emphasize the nature of the market you're entering. And Nigerian market should not be perceived from my opinion, as a dumping ground where anybody who can get a license elsewhere come to Nigeria and think that's where they just can start making a lot of money without having to comply. So as for compliance costs, I don't think as someone in the compliance industry, which our main business is advisory, I won't say that compliance should be overlooked by virtue of just cost itself. You look at the implication and what your users stand to benefit and the benefit that arise from it. It's a profitable business if it's run properly. At the same time, emphasis should spend on the impact of what the compliance stands to achieve. I think that's where I stand on this.
Thank you, Jonathan. So I hear you more of a reputational cost issue in terms of what products are being developed by these operators, and that should be what the focus is in. And of course, that small operators or companies coming in should be ready to, is it pay the price really, high risk, high reward? You need to do what is involved or be ready to be able to, permit me to say, play with the big boys. Yes, thank you for that, Jonathan. I'm going to go to JEE now, because as Adetun had mentioned, international operators, we have more of international investors and involvement. Understandably so. It's a $2 billion in industry in Nigeria. There are over 60 million Nigerians placing sports bets every day. We have about 51% of Nigerians doing this. I understand over 5 million USD is being made or utilized on sports betting each day. So really, what it's clear that the sector is thriving and attracting investors. So how should international operators or investors prepare for localization requirements coming into Nigeria to play in Nigeria? What should they be looking at, maybe in relation to data protection, subscribers' data, how it should be handled, even in terms of ownership structures in setting up their businesses in relation to, is there requirements for local participations? What really is the position, and are there risks that they should bear in mind? Is this something that is already in place? Is this something that is likely to happen?
Thank you, Chief, for that question. And I'm going to take a lead from what Jonathan has said, and what Adetun and Told have also said. They've all mentioned the changing landscape and the need for compliance and reputational issue. So localization is already a thing in play. I know I had assisted some lottery gaming companies to set up in the past. I know that in Lagos State that's already in effect. So what are we seeing in the market? First of all, I'll talk to other regulators and not specifically the gaming authorities. First of all, the FCCPC already requires foreign platforms to comply with Nigeria consumer protection, obligations in Nigeria. So that's only another localization issues that international companies looking into the gaming industry should be looking at. Also, there's also extended compliance with the anti-money laundering compliance, right? So gaming operators, including foreign-owned ones, are now having to do extended obligations for extended disclosures, because they're now designated they're not designated for filings under school and all that. So it's something that they need to pay attention to. That's something that's it's in the local laws. Also, we also look at on the state level, like Lagos and River States, I've already mentioned Lagos State, there's increased demand for, foreign participation in your business. So that's our localization that are already existent in Nigeria. So you ask, how do people, one industry that I want to borrow a lead from is the telecommunications industry. You realize that when it was being started being regulated, foreign operators, initially entered, there were fewer regulations. But as things began to progress in the telecommunications industry, you will see there were rules around localization of infrastructure, data centers, partnerships became, standard form over time, right? So, and the gaming industry is on the same trajectory, if you ask me, right? So, what are practical steps that I would advise from a regulatory perspective that I'll be advising foreign participators? First of all, just structure early. If you're looking at coming into Nigeria, why don't you think of all the JVs, technical alliances with credible entities that will position your business for, for this localization that is already in play in some states, and looking at the harmonization and all that, I'm sure that's something that's going to come across all states soon, right? I also talk about alignment with governance in the Nigerian industry. Because I'm a lawyer and I'm a governance expert, as you all know, I'll speak about CAMA. There already players and regulators already expect some minimums from you. Your board composition, your shareholding structures like Lagos State, your compliance, which Jonathan has already spoken about. They must all align with Nigerian governance requirements, to build credibility in the gaming industry. And finally, you companies have to start planning for cyber and data localization. Firstly, the Nigerian Data Protection Act has and some state regulators have been increasingly vocal about, housing local data within the country. So, as an international operator, I think these are things that you should start to build into your system, because I always say that, it's the regulators with very nimble compliance systems and regulatory engagement strategies that really thrive in markets. And this is no different for the gaming industry. That will be my concluding remarks as to, localization and what companies should do to prepare. So it's structure early, align with governance laws in Nigeria, and plan for server and data localization. Thank you.
Thank you, Yeye. We heard that loud and clear. Structure early, prepare for these requirements, prepare even as you're already coming in, possible data localization, compliance demands, and all other regulatory requirements that would apply also to local as well as international investors coming in to operate in the space. Thank you for that. Adito, I'll be coming back to you. We've talked about the universal reciprocity certificate. You also talked about, the federation, FSGR, and enabling states and allowing states to come on board by setting up their own regulatory frameworks in place, having their laws in place. So I want to ask now, in terms of the regulatory autonomy that states are then required to have as members of the FSGR and coming under the URC license, how then can there be some preservation of regulatory autonomy among these participating states?
Yes, thank you for that question. As to retaining the sovereignty of the states, even while collaborating in this industry, that is a provision of the Constitution. And we, as members, are willing and ready to abide by that. And that has also been further emphasized by the pronouncement of the Supreme Court in the judgments, that celebrated judgment that we are all talking about. Therefore, each federating state in that community will continue to retain their autonomy as regards regulation. And you would understand that what we are trying to do as a group, as an association, is to ease the body on intending and duly licensed operators, to eliminate all areas of multiple licensing, basically, because that is one thing the operators have complained about severally, even before now. And that is what we've been looking out to make sure we attend to as a listening organization. So what we intend to do is to ease the burden of operators, but we will still ensure that all states reserve their sovereignty as regards taxation. All states will still manage their gaming taxes. All states will still manage their compliance and enforcement, though there will be reciprocity. Yes. If you are not compliant in a state, in any part of Nigeria, the state has a right to inform the federation, and the federation will look into it once we are able to prove that that operator is operating in that state. So there will be reciprocity as to compliance, taxation, enforcement, and all of it. But as regards licensing, there will be one single license. And this much we have discussed within ourselves as regulators. This much we have informed the operators. Recently, we had issued a letter to the Association of Nigerian Bookmakers to inform them that that operators need to begin to relate with every state regulator they intend to work with. We don't want to just throw down instructions from the center. You need to know your regulator. They need to know you. We have that privilege in Lagos State because most times our operators, we have regular sessions, we meet regularly, they have that confidence to walk up to us when there are challenges, and we're always with them. Even on the issue of other federal agencies of government, whenever they have issues with any of these agencies, they are quick to run to us, and we always stand up with them. We have a very good relationship with SCUMU and EFCC when it comes to our operators in Lagos State. Whenever there is a session, even with EFCC, we will, with the operators, Lagos State Office and Gaming Authority will always attend because we want to make sure, even SCUMU, they know that they will have to inform us and we will be there with them. So we are trying to ensure that each state also grow along this line. They are able to manage themselves, manage their operators, and they are able to stand on themselves. The purpose of the collaboration is not to affect their sovereignty as a state, as has been constitutionally provided for. It's just to make sure that we work together, we set up a standard, which even while sleeping or dreaming, you know what it should be, what is obtainable in the Nigerian gaming industry. We've been to some international conferences and we've had some of the intending investors say they are worried about Nigerian gaming industry because it's not regulated. When we hear things like that, it gives us worries. So we are trying to work towards removing that narrative to make sure that even from wherever they are, they can ascertain what it is to be, what it is, and what will happen in the industry. So each state will retain their autonomy, but we are trying to harmonize the standard, the policies, the procedures. Taxation, states will handle. Enforcement, states will handle. Compliance, states will handle. But there would be a standard. It will be harmonized and there will be reciprocity. If you don't comply in one state, if the association is aware, we will make sure that the association stands up to that operator to make sure that they comply in every state where they are operating. So it's not going to affect the sovereignty of all states. All states will still retain their. It's given to them by the Constitution, so we don't want to affect it. Thank you.
Thank you, Adito. Yes. So what I hear is predictability in the industry is really part of the focal point. So that in terms of the easing the burden and the harmonization, but as expected and as constitutionally provided in relation to taxation and all the other expected autonomies that states are required to have, it is not being interfered with in any way. Great to hear that, Adito. And I think I'll be asking Jonathan, just even touching on this same topic, looking at the fragmented state level regulations, what then is the effect? And it was confirmed that tax planning and all these other expectations are relying on the states to develop as they deem fit. But what then is from an industry player, from an operator standpoint, how do these different regulations affect your tax planning, treasury management, and then financial reporting? Jonathan.
All right, thank you. I think it comes with a lot of like uncertainty because it's being proposed and it has, I think, for issue of practicability. How practical is this? Because it raises concern as to, yes, it's a uniform license, but you have quite a lot of states which have different proposed regulation as regards gaming. I think that will be the issue as an operator to know where do we start from. And it seems like emphasis is spent at this point, from my opinion, on, lots of time is spent on looking at the state's requirement rather than focusing on the business. So you have quite a lot of, responsibilities in each state. As she stated here already, some states already don't or still do not have a board. And in terms of, let's say, the new withholding taxes being applied on winnings, you don't have a clear route on how to make such remittances. So reporting wise, you have to make provisions in your books, assuming that, there are different IDs or customers in states that don't have a clear defined remittance of their withholding taxes. So you have provisions in your books sitting there waiting till when you have clarity on how to go about it. So in terms of reporting, it means there's quite a lot of planning, consideration taken into effect. You're going to have to increase your manpower just to make sure you're compliant in all the states, and it comes with a lot of responsibility. The gaming operators in the states, in the country as a whole, they want to comply, but the ease at which complying takes effect will do a lot good to their business. No operator wants to spend more time in taxes rather than focusing on the growth of his business, because the essence of the business growth is to be able to remit to government. So the fragmentation in terms of reporting, taxes, treasury, it has a lot of planning. It's a lot of planning, and to look at different states, the rights to you, demanding you have to make provisions, you have to, go through certain processes, more like reviews, audits, etc., etc. It kind of provides a lot of burden as to planning. A lot of burden as to some states don't have an online platform to remit taxes. So you mean there'll be logistics, there'll be, representation in those states to actually to be accountable to those states. So, as the point of or the at the perspective of an operator, the fragmentation brings a lot of uncertainty, and that's how I say it. Therefore, the reciprocity arrangement, it answers the question in one way. Yes, uniform license. So you have one license that can operate in about 24 states. But in terms of the uniformity of the compliance as regarding gaming laws, as regarding remittances of taxes, which is at the sovereignty of each state they need, it also brings a lot of effort, a lot of accountability. So for operators, they want to comply. A central platform to enable them do that will really be of help. Also, again, information being out there, because lots of informations in Lagos, for example, you can find it online. It's pretty straightforward. Some states, you can't find anything online. You have to go and search. You have to send a representative. You have to look for maybe newspapers in those states and see whether you could get information to be able to be compliant. So it's a win in one aspect. Another aspect, it creates a lot of cost, and that's how I see it.
Thank you, Jonathan. I think Adeto, you may have comments on that. Really, hearing from the from an operator's angle, and then looking on the regulatory side, what the pressing issues of the conversation seems to be, and what then is the federation looking at in relation to how to maybe address some of these issues Jonathan has raised.
Thank you very much. As regards the fragmentation on other aspects apart from the licensing, I am of the opinion that before now, somehow the operators have been managing to work with some of those states. From the federation, we don't think it is proper to just yank it off those states. That's why I have said it's a work in progress. All these areas would also be looked into. All of these areas will be standardized, and all of these areas would be harmonized. But it's a slow and steady process, because it involves not just the regulator. There is the ministries of finance, there is the attorney generals that are involved, there is the House of Assembly of each of the states that are involved. So it is not just the regulators. If it is for us, the regulators, together to harmonize all of this thing is not too much of a problem, because we meet regularly. But even after we meet, there are other powers in the system that will still have to look into these things and need to know how it affects each state. So as for the taxes, we are able to agree on a percentage, but as much as possible, we don't want to just push it down, because when we had a meeting with some of the operators, and we suggested a percentage that should go from all the states, some of the operators did object to it, that even if they're going to pay that percentage in taxes to Lagos State, they can't pay that same percentage in some states. That was why we came up with, okay, if you think you can do that with Lagos, or maybe your maybe Anambra, and you think that is too much for you in some other states, okay, why don't we allow you negotiate, speak to them based on your market in that state? That's why we come up with that. We were ready to just come up with, okay, so percentage of GGR or for the monthly taxes. But immediately it came up at a meeting, the operator stood up and said, no, that cannot work. I can't do what I am doing, the percentage I'm doing in Lagos, in other states. So we said, okay, all those things is a growing process, it's a teething process. Okay, go and work with that state based on your market in that state. Let's see what you can work with, and then we can all come back again to now see how all of this is going to work out. And even that of the reporting, we want you to speak with your regulator. Whenever there's an issue, the federation is available. And fortunately, the headquarters, the secretariat, the chairman is in Lagos. And most of these operators have their businesses more in Lagos. So we're always ready. Whenever there are issues, we are always willing to intervene, even when it concerns other states. And all the other states are always willing to speak with us and to learn from us. So I want us to believe that all of this thing is in the interest of everybody. Let's work with it. Let's see what is possible. Then at every point we can adjust. We can adjust, then we can, I'm sure that we'll get to a stage that everybody will be comfortable with. But this is a teething period for all of us. And I'm sure we'll get to where we all want to be. Thank you.
Thank you, Adeto. I think I see Jonathan smiling a bit, a bit of satisfaction from that response. But yes, thank you for spotlighting as well, like that inability of maybe blanket taxation considerations being applied to, every state involved, and looking at maybe where operators are assessing, how much revenue is being obtained, and being able to go and have those conversations directly with the state regulators, and maybe involving the FSGRN where there are knotty issues, like an escalation sort of process. Thank you as well, Jonathan, really touching on all those points and raising, highlighting those areas that still need to be further treated. At this point, I just want to mention that there's a Q&A box open. Attendees, please drop your questions. Okay, I think one has already come in good. We'll be taking that at the end of our panel session, going to the general Q&A, but just wanted to announce that, we can, please feel free to drop any other questions that come up. So I'll go now to Tolu, because really Jonathan has led us there, Aditun has also brought us there. How can the operators better be assisted, better supported to engage with these regulators? What are key areas that you would say, that operators would need, urgent support or clarity to be able to carry out their business activities in as long as in line and being compliant with requirements from state regulators?
Thank you very much, Kojichi. It's quite interesting, and from the conversation with Adito and Jonathan, and I see that they've also, touched on certain areas which I believe that operators in engaging with regulators, operators in the lottery industry are going to be faced with like three major areas. And I like the fact that Adito mentioned that there will be harmonization, and they're looking into harmonization because right now there's a lot of uncertainties within the industry. So for me, from my own point of view, in engaging with regulators, operators in the lottery industry are going to be faced with three areas of urgency. And one is with respect to clarity on licensing and regulatory continuity, particularly in three aspects. So operators require guidelines in transitioning from the default NLRC federal license to state-issued licensing. So it's particularly important due to the abolishment of the Federal Lottery Commission. So while operators would need clarity on the continued application of the NLRC license, particularly regarding its continued recognition or replacement with the proposed universal reciprocity license. So there will be a lot of support from regulators in navigating state licensing framework. And I'm glad that Aditun, mentioned that part during our answer, including making available state lottery laws and its attendant regulations and guidelines thereunder. Secondly, I think a lot of operators would also require support and clarity in regulatory harmonization. And that's why I said, she mentioned that during our answer about harmonization and consistency among states, because the decentralization regulation, operators must be able to manage the disparity in standards across states, and standards such as licensing terms, compliance requirements, enforcement practices, and also, additionally, operators need clarity on whether some states will share uniform procedure or standard, especially in licensing, anti-money laundering, AML, responsible gambling, dispute resolution. So operators require harmonization due to the cost of these licenses and compliance requirements that might increase complexity in the lottery industry. Thirdly, I would say that regulatory authority moves to states one of the things that would also, they require clarity is to face uncertainty around states' readiness to enforce. And I'm glad that Adeto, while she was speaking, she talked about autonomy in terms of taxation, autonomy in terms of enforcement and standards. But there will be standard for everybody, but they would retain their taxation, enforcement, and autonomy. But of course, once they retain this, it's also very important to let operators know, because this is very uncertain to them, the readiness to enforce, administer, and monitor gaming activities, particularly in online or tech-integrated platforms. The technical, administrative, and staff capacity of state regulators to be able to issue licenses, ensure compliance, and manage enforcement effectively. So accordingly, operators would need support in assessing guidance, assistance from regulators, such as the Lagos State Lotteries and Gaming Authority, which has begun the outreach and transitional support. And as the conversation is going, I'm like, there's going to be a lot of work for Lagos State, because this seems to be the one that's really, be able to understand the industry and being able to, create a standard. So operators requires the capacity, like building initiatives, training programs, technical support to help regulators adapt to the new regime and reduce operational friction for operators in going into different states. So for me, I think this would be like the three main issues that operators will need clarity on, especially with this new landscape that we are discussing today. Thank you.
Thank you so much, Tolu. So,
But I should mention, I should mention that every new regulation may feel like a challenge, but it's also an opportunity to strengthen the sector. And also, even for the operators, it's very important for them to just know that compliance isn't just about following rules, it's about building trust in the industry. And since they're also going to be making money, it's very important not to just see it as a cost, which I think Jonathan mentioned, but more of a competitive advantage. Thank you.
Thank you so much, Tolu. So guidelines for operators, so bringing them, familiarizing them with the new regulatory position, how it would affect current business, standard harmonization, and then as well capacity of enforcement, which Adeto had also kind of mentioned, states developing at their own pace. That is something that would really be essential for operators to be aware of and on board with. Thank you, Tolu, for that. Jonathan, I'll come back to you to look at the financial effects of the anti-money laundering, know your customer, the systems. What would you say, how should operators look at budgeting for stricter requirements along those lines in terms of the audits? How can they also avoid, minimize or mitigate risks of fines? What kind of compliance planning can be put in place on a finance angle?
All right. Thank you. Regarding fines, I don't even think the emphasis should be on fines. I think whether there are fines or there are no fines, I still refer to what I said earlier about brand reputation. The brand reputation should really be more matters more. The brand should not be seen as probably free for all, where the all sorts of activities can take place there. People can launder money. People can use it as a platform to finance terrorism, or can be used to do all sorts of fraudulent activities. That's something that should really matter most to operators. They should spend more time trying to ensure that they have very good reputation with their customers. Customers see it as this platform is used for what it's intended for, not seen as, oh, if you have any dirty means or shady businesses, this is where you should take your money to. I think that should be the paramount focus for most operators. However, to enforce this, I understand that there is a business aspect to it, which is it's necessary that operators actually look beyond that, because in terms of KYC, lots of operators have been able to bypass this requirement in terms of signing up for users. Users have to sign up without having to do lots of, if possible, in some cases, not any KYC, probability when they get to win, and they try to make it as easy and quick for users to onboard. It's part of a strategy by some operators. You just your phone number you're in, and you can start gambling. And also, in fact, I know you said about just AML and KYC. Also, again, there's risk of responsible gambling. I mean, the underage betting where customers come in there without even verifying their ages. They've already started gambling and interacting with that platform. I think these are the risk part of it. So it's a thing of responsibility of the operators as to maintaining those high standards while maintaining its business competitiveness with its competitors. And also, again, I know that the regulators also have to do their have a role to play as to probably spot checks in terms of looking at websites and how the onboarding exercise takes place from start to finish. I know it's some of the lottery boards in Nigeria already do that in terms of like mystery shopping, going there to see how well the platform are run in terms of the safety of the customers' identity in terms of KYC, because there's a risk of identity theft, there's a risk of fraudulent activities as a result of the financial records like banks accounts all listed on this platform. These are the risks that could arise as a result of not complying with all these requirements. So that takes us to data protection. How those data are stored, how they housed in terms of the user's identity, the user's sensitive information. I know some cases when you win, you're required to send your ID cards, which you have your NIN number. In some cases, you may have your BVN number. So all these informations are very important, and they're very, very, very critical. That should not just be stored away just anyhow at the having access to it by just anyone. So the cost of this, it shouldn't be the emphasis or the risk of finding reputation could come first. Secondly, they should know that the industry has its policies, its regulation, and and finally, I think the emphasis should move or just not from just doing it for fine's sake. You just should look at the long-term plan, the long-term implication for the organization, especially when you're looking at being a market leader in Nigeria. You have to really lead the steps. So certain brands lead in terms of compliance and others follow because they have set the pace. And also the regulators as well are probably doing their role in ensuring this happens. So that's my take on this.
Thank you, Jonathan. Let me just ask additionally, there's the CBN proposed real-time financial transactions reporting, which would affect operators being designated non-financial institutions. What's your take on being able to have those kind of maybe infrastructure or the technology in place to be able to make those kind of reporting on them suspicious activities in that real time as required?
Yes, I think it's one thing for the CBN to make these requirements, which is all right, and betting companies should fall under it. However, internally as a country, we know that in fact, let me say 99% of the betting companies in Nigeria, the platforms are not run here. So it's part of what was said in terms of localization. I think there should be investment or incentives to make sure these things are localized. You want to ensure that we understand the business ourselves. Most times I speak to people or regulators who are catching up in terms of the infrastructure, the know-how. We have very few of the servers here, platforms or providers. We don't have anything localized, so we have to rely. And again, we're looking at real-time transaction count of, let me see, nanoseconds, maybe 1,000 transactions per second. You're looking at these things happening real time, so you have to rely on data coming in at influx, and all these things sometimes have to do with, we don't want it manual where people have to go, line by line filtering at the end of the day. It can't be real time then. So if we want to have these things real time, we have to invest, or we have to give incentives to those who have this operator to localize them for our benefits.
Thank you so much. Thank you so much, Jonathan. Tolu, let me ask you, he's spoken on like the financial effects. What would you say in terms of the legal aspects in relation to these anti-money laundering obligations, being tied to license renewals? What can operators also be doing to avoid penalties? Yeah,
okay, yes. So for them to be able to avoid penalty, I think the first thing is to make sure that they have the KPI in place to be able to know what to do. And also the AML compliance also should also be in order so that you'll be able to know and then set up a system in place within the organization where they have people on board that will be able to identify the penalties, and then they would they're not going to incur costs about that in terms of penalty payments. So they should have a KPI in place, they should have a compliance, AML compliance in place, and also they should have like a checklist where they will look at the different things that would need to be carried out in order not to be able to incur costs for the penalty.
Thank you. Thank you for that, Zulu. Jonathan, I'm coming back to you. We're looking kind of towards the future, looking at digital currencies, financial implications. SEC has identified, cryptocurrency as digital assets, basically maybe legalizing the position, which for a while has been here and there. So with fintech and gaming increasingly overlapping, what financial compliance risks, are likely to catch operators off guard? What should operators be aware of?
Okay, I think before we go that far, I think in terms of cryptocurrency, there's already a risk of them losing businesses to non-licensed operators outside the shores of Nigeria. So with the ability to bet in crypto, there are lots of operators who don't have to be based in Nigeria, because crypto, the wallet address and all its infrastructure can happen without having to be localized. So you have lots of operators right now who are not based in Nigeria accepting bets or crypto deposits from Nigerian users and operating. And with this taking place, the operators in Nigeria who are registered are losing businesses to them. Is that they are disadvantaged. So that for me is the first challenge. There's a business risk attached to this. Also, again, when it comes to this sort of technology advancement, there's a risk of cybersecurity. You're having, DOS attacks from, different, maybe unsecured URLs. You're having lots of different aspects of the businesses being exposed to, potential attacks from all places. I know there has been one in recent times, and when you're having technology expositions, you need to have regulation with them also as to the kind of platforms and how secure these platforms are in terms of where your servers are hosted, where your different security keys are actually hosted and tokens. So these things are very important in terms of technology advancement. Also, again, you're having issues of duplicate websites. Like I say duplicate websites, or I'll call it you know, impersonated websites. You have websites with similar URLs. Probably, maybe I'll give you an example. Maybe jacksonbet.com. You have .com.ng or .net. You're having identity theft in such a way that you have platforms that looks identical but are not the same. So you're having such kind of issues arising in terms of technology, and this comes with, and also again, I use this opportunity to raise the concern about how, let me not say raise concern, but at the same time trying to ensure that the regulators in Nigeria, especially at the certain levels, can be proactive when it comes to dealing with this, because we have had situations of websites that are kind of identical operating, and despite they've been reported several, they are still standing there. So I don't know whether that sits with the National Security NSA or sits with the DSS, but those are the kind of help we need as to in terms of technology to protect the operators here in Nigeria. So those technologies are good. They're coming, and the regulation in Nigeria is catching up. In terms of crypto introduction, I know the SEC has released some things as to it, but in terms of central bank, we're still waiting for how well this can affect it in terms of the regulatory framework, because some countries have more advanced framework that deals with the tokenization, its acquisition, the storage of the value, and how they tie this to, like, USDT is tied to Tether, which is the US dollar. So maybe at some point, I know the CBN tried this e-Naira at some point. I think we probably will have some regulation. Nobody can just wake up one morning and start a coin, and next minute everyone is buying to it. So these are the kind of areas that need more regulation. So we're having bets in some countries where they are giving tokens for winnings, and people can claim those tokens against in different markets. And you have players who use their IPs and play from Nigeria. So it's very important that these things are happening, but regulation is also catching up. The government is also being proactive in terms of taking down some sites that are not regulated or within our space. And also, again, we're also looking at different measures that existing operators must comply with in terms of cyber security and data protection. I think I leave it at that.
Thank you, Jonathan. Tolu, I'll ask you because it's related to this really. What enhanced due diligence measures in looking at the Nigeria's anti-terrorism financing laws, for those operators that are accepting this cryptocurrency, maybe applying tokenization as well, what enhanced due diligence measures should they have in place so that they are, complying with the anti-terrorism financing laws?
Okay. Thank you, Kadichi. So basically, for operators in the lottery industry that accept cryptocurrency and foreign currency, Nigerian anti-terrorism financing laws demand a higher level of scrutiny than ordinary compliance measures. So I think for me, enhanced due diligence begins with rigorous verification of customer identities, ensuring that onboarding processes captures reliable government issue identification, cross-check details against domestic and international watch lists. Operators are also expected to establish the source of funds, requiring documentation that demonstrates the legitimacy of foreign currency inflows or cryptocurrencies holdings. So operators must apply stricter thresholds on transactions that from flagged jurisdictions, subjecting such customers to monitoring and approval at senior management levels. Given the anonymity and maybe like the cross-border nature of cryptocurrency, operators should integrate blockchain analytic tools to trace wallet activity, detect unusual transactions patterns, and flag connections with addresses linked to illicit activity or terrorism financing. So for foreign currency transactions, enhanced monitoring of cross-border flow is very, very necessary, with an emphasis on identifying unusual transaction sizes, structures, the frequency of such transactions that do not align with the customer known profile. So I think if all these things are put in place, operators must document their due diligence processes and ensure timely reporting of suspicious transactions to the Nigerian Financial Intelligence Unit as required by the Terrorism Prevention and Prohibition Act. So there's an act that, specifically stated that for any transaction that is suspicion, they need to report to Nigerian Financial Intelligence Unit. And I believe that if all this is done and they have an enhanced due diligence, it might be safe for them to be able to accept it. Thank you.
Thank you so much, Tolu. Documentation and reporting is key. Something Jonathan has said, I want to now, you just permit me to plug in JEE because he talked about duplicated website risks. So Jackson and Edu were brand protection experts. So, operators in that space having those kind of issues should know the right place to go to, to ensure that their brand and those reputational risks are avoided and the goodwill of the brand name is not being, utilized wrongly or benefited by wrong persons. So just to plug in JEE as a law firm of choice. Thank you. We are wrapping up around now. I would second to last question would go to Adeto. A lot has been said really, and there are a lot has been said really, especially hearing from the operator's perspective, and then what maybe like a lot to kind of take back on the regulatory standpoint. So I just want to ask you really, over the next 12 months, what specific measures should operators be expecting from Lagos regarding enforcement practices and licensing transparency at its own?
Yes. In the next 12 months, Lagos State will be prioritizing predictability, transparency, and fairness in our regulatory framework. Over the next 12 months, operators should expect one, the rollout of digital licensing and renewal portals to enhance efficiency and reduce human interface. We intend to roll out a digital platform so that it makes licensing, acquisition and renewal easier for operators. Then would intend to publish our guidelines on enforcement and sanctions so that operators are aware of what happens when there is a breach or there is an infraction. So the guidelines as to enforcement actions will be clearly published. Then we intend to have stronger collaborations with other government agencies, financial institutions to ensure that we strengthen our compliance monitoring and work around our responsible gaming and anti-money laundering policies. Then we would be having more stakeholders engagements with operators and other agencies that has one or two things to do with the gaming industry. Aim basically is to ensure that there is clarity, there are regular dialogues, and we want to minimize surprises if possible to eliminate it. Then secondly, Lagos State is seriously working on responsible gaming policy. And for this reason, Lagos State has recently introduced the Safe Play platform. The Safe Play platform, we had a launch earlier this month. It was a press conference, and about 2 weeks after, we met with the operators to also introduce this platform. And like I told you before, we're always willing to engage operators. So the meeting of last week was to introduce it formally to the operators so that we can get their feedback. And we have like a month to work with the operators so that we can have a back and forth on it so that they can express, because that day they expressed some of their concerns. So we are looking into these concerns so that we can have a platform that is unified and that would encourage all operators, if not mandate them, to plug into, because it has to do with responsible gaming. And responsible gaming is one of our core values. It is important because it helps us in the gaming industry to gain credibility and show that we are committed to our consumers' protection. And it is in line with what happens, what's obtainable in international communities. And for this, technology is going to play a major role because it's a platform which will ensure that it's accessible to all operators, and all operators must key, because once you are on this platform and a punter self-excludes with an operator, it sends notification to all the other operators to know that this person, this player, this punter has self-excluded himself. Because we have situations in which a punter will exclude with one operator and continue to play with another operator. We have had situations in which punter would send complaints to us that he or she self-excluded, and he was allowed back within the exclusion period. So we want a platform which we as the regulator can monitor and be sure that all operators are compliant with this responsible gaming policy. And once we are able to settle in on it, this platform will be extended to other states. It is part of our harmonization policy, but we will first do the trial run in Lagos State. And once it is done, then other states will begin to harmonize. So in Lagos State, we are into a lot of things and we are always up and running. And I also want to quickly speak to what Tolu said about clarity on transition for NLRC regulators. we have policies in place. We have made publications to that effect, that operators who were either to operators with NLRC certificates should come in. We have a policy that will provide soft landing for those operators. If their license is still operational, they should approach the federation. They can approach Lagos State. We'll tell them how to onboard them when the federation is ready. So we have provision for all of this. And as to our regulatory harmonization and sharing information and procedures, like I said earlier, we are always speaking to our sister regulatory agencies. Yesterday, the Taraba State teams were with us. About 2 weeks ago, Edo State was with us. We would share our programs with them, our policies, we share our laws with them so that it will guide them in preparing their laws. Some of them already have, some of them need to update their laws. So we share our laws with them. We share every information we have with them. So all of these things, we have that major aim to harmonize every aspect of gaming so that all stakeholders can have comfort, so that we can have integrity, and so that there can be predictability. People would know that this is what should happen, this is what will happen. I should leave it at that. Thank you.
Thank you, Adetong. Yes, I'm sure that the vast efforts of the Lagos State Gaming Authority is being duly recognized in terms of all the different activities that will be taking place. The launch of the Safe Play platform, looking at collaboration with other agencies, more digitization efforts being on their way and releasing more guidelines on enforcement. Thank you so much for really sharing that with us. To now close out our panel questions before we open it up and look at the Q&A from the audience. Looking forward, Adetong has touched on Lagos and what operators should expect on that aspect. Just looking forward, what should operators have in mind in terms of legal risks in the next 3 years? What sudden regulatory hurdles could actually blindside operators? What is the forward-looking approach and the preparation that should be in place?
So, this question, from everything that is mentioned by Adetong, the question is, she has allayed the fears of investors in the country, saying that, no, there's open platform, there's interactions, there's guidance from Lagos State to other states. So, my question has already been answered, but be that as it may, I'll just throw some light. We talked about licensing, the licensing issues. Jonathan has spoken about, financial planning, because some states don't have the infrastructure to meet up to the demands of the gaming industry at the moment. Those are all issues that are already in the sector. However, what's the sudden, as asked me, the sudden hurdles that may blindside regulators are a few that are already happening. First of all, sudden prohibitions in states, right? There's currently, I know Kano State has banned sport betting. So it clearly shows that any state, and Kano has a very large population. So you can imagine if, in the unlikely event that's emerges in others, there's sudden ban emerges in other states, then there's a portion of business that'll be lost by operators. So it's something that we should also look at. Maybe some states may accept and some states may not accept this sports betting due to cultural differences and other social political issues. So those are something that operators should look at in their planning. Another thing which I have also mentioned is the mandatory partnerships. I know that last year the State Lottery Board floated some draft guidelines. I don't know whether it's now in their operations, but I know that they floated some guidelines. And if you read those guidelines in details, you will see that there is some allusion to some modeling that encourages states partnership with state-backed entities, right? So given that everybody has a voice now in terms of harmonization and all that, and this may come to bear, so operators should also in their planning also look at if those mandatory partnerships are enforced, what should we do? So I would encourage them to start looking at that. We've already talked about localization, right? And we talked about the NDPA, the Data Protection Act, and some ICT policies that have. I mean, I know Jonathan spoke about the fear of the security around hosting your servers, security issues around hosting your where you host the servers and all that because of the sensitive data they carry. But given all the regulators have been very vocal about data localization and all that. So, I mean, in terms of your 3-year projection for operators, I think this is something you should start looking at. Look at how to, if this comes into if it comes into law, how do you intend to localize your data? How do you intend to plan for security of the information that you collect on those servers and all that? So, for me, in my closing remarks, I would always say it's the companies that have really, really nimble, flexible compliance systems that really thrive in this industry because the trajectory is going this way, right? There's regulation, there's commitment to regulation, there's commitment to stakeholder engagement. So in summary, I would just say, start to look at your state level compliance. What are the things that are muted by regulators, localization of data centers, partnerships, just start to plan, put it in your forecast to say this, if this happens, we're not caught off guard. And in long term, what do you need to do? Prepare for the unpredictable shifts in regulations, right? Have a great financial and legal partner to work with so that in terms once this if these things that are muted here and there come into light, your systems are quickly adaptable so that you do not lose operations, right? If, for example, one state says, oh, you cannot operate there, is there a fallback state with the same capacity where you're already operating, or you're already forecasting to operate, right? That you can actually catch up on that market because gaming as much as it's spoken of, is a business, right? And people are in a business to make profit. So those are the long-term adjustments I'll be advising operators start looking at in their forecast and their plannings as the year is coming to an end and having those board meetings and strategic plannings. I mean, those are these 3 big things you should be looking at this time so that you remain agile and compliant for tomorrow and also today. Thank you.
Thank you so much, Yeye. Thank you for those closing remarks. Thank you for spotlighting those areas. Thank you, Adeto. Thank you, Tolu. Thank you, Jonathan. I know that the attendees, my audience will agree with me that my distinguished panelists have done justice to this topic. They have gone above and beyond. I really want to express my gratitude for that. My colleague will be taking the vote of thanks shortly and, would speak more on, the success of the panel. But I want us to quickly take the questions in the very little time we have left. We are about wrapping up. So we'll just quickly take the 3 questions that we have here. Okay. Adeto, did you want to say something or I can proceed? Okay, all right. So we have a question from Victor. Yeye, I believe you would respond to this. Do you think consumer protection concerns under the FCCPA and NDPA could in time create as much liability exposure for operators as anti-money laundering breaches, especially given the sensitivity of personal data in the gaming industry?
So my short answer, which I'll explain further, will be yes. I think we're getting there. If you look at the FCCPA regulations, they're already talking about, there's already direct liability for unfair contract terms, misleading advertisements, inadequate redress mechanisms. So the FCCPC is already showing willingness to sanction, companies that are not, compliant with fair practices for consumers. Also, the NDPA, already elevates, data privacy from just guidelines to statutory obligations, right? So you're already expected to comply, and there are also fines for non-compliance. Then again, there's also, we've spoken on this call about, responsible gaming, and children and vulnerable groups, right? And this is one thing that SCCP is already looking at, that you must always be fair to consumers. That means having, procedures that, protect these people. So if you compare, what the FCCP is doing and what the data protection agency is doing, you will see that if I know if you breach anti-money laundering, it's a criminal offense, liable to fines and all that. But again, if you also breach data protection and consumer protection rights, right, there are also financial and reputational risk, as we've already mentioned on this call. So really looking ahead, we are looking at, FCCPC and NDPC's actions, will carry the same weight and fear factor like the AML, sanctions by the NFIU and CBN. So operators that fail to prioritize consumer protection and privacy may see themselves in big trouble. So I would say the answer for me is yes. They will carry the same weight. One will be reputational, and reputational fines. The other will be criminal liabilities. So my answer to that will be yes.
Thank you, Yeye. There's another question here. Are there any specific, significant operational and strategic challenges sportsbook providers face in their partnerships with operators in Nigeria going forward? Jonathan, would you want to address that?
Okay, yes, thank you. For sport providers, they provide services to gaming companies as gaming operators in Nigeria, so there will be tax implication as well for their services. Also, again, by virtue of I think that's the Finance Act in 2024. If you do like the terms of definition of significant economic presence, they will need to register in Nigeria. I think a couple of them have done that and already registered in Nigeria to be able to withhold or remit VAT. So those are the likely areas in terms of taxes that sport book operators are likely to face. Then also again, in terms of data protection, I think that's what is something that must be looked into in terms of the data they collect and having to be compliant with NDPR. So they have to look at all these areas as to how it affects them. Also, again, I'm not too certain, but I know there was a time in terms of technology in Nigeria, there was a technology establishment that has you to register your technology in Nigeria. I don't know if a couple of them are registered to that particular aspect. So those are the areas that really should be emphasized. And in terms of new, but probably because the current administration is making some changes here and there, so it's also important to stay on ground with the latest developments and how they impact your businesses. So that's it from my end.
Thank you, Jonathan. And the point, especially on NOTAP, National Office for Technology Acquisition and Promotion. Yes, exactly. So dealing with technology, as you explained earlier, that they tend to be from the international operator and not much on the local side. So just in terms of that regulator being the one in charge of regulating that and ensuring that, local partners or licensees, how the money is being paid and being remitted is in line with those regulatory requirements. Thank you. The last question here, Tolu, maybe I'll throw that to you. Using key indicators, what does a strong compliance culture look like for a gaming operator in Nigeria's regulatory landscape?
Okay, so I was saying that for me, with the Supreme Court's ruling, rising compliance expectation, a strong compliance culture for a gaming operator has some indicators that will be identified that people should, watch out for. I think first is a leadership commitment. When you have the board or senior management that actively championing compliance, not just like it's legal, but as a core business value. So that's one strong compliance culture one should look for in an operator. Also, having a robust AML and KYC processes, which I think I mentioned the other time, like strong system for identity verification, anti-money laundering checks, suspicion transaction, reporting those things and adapting it. Basically, like there should be like a seamless integration with local identification system, like the NIN, BVN, and there should be a clear audit trails for this big thing. And another culture that one should look for, a good indicator would be responsible gaming framework. So a proactive measures like self-exclusion tools, betting limits, customer education, clear age verification protocols. I think he mentioned something about age verification protocols should be in place. So with this, players can easily opt out and set limits, and staff are trained to, spot harmful gaming behavior. So these are cultures that one can actually look at with operators that have good cultural integration and transparent reporting and record keeping, technology and data governance. I think we've mentioned a lot about data governance in this regard. So there should be like a secure state compliant data storage on how they store their data and meet with multiple state regulatory requirements now, basically. So, and lastly, for a good strong cultural framework will be a proactive regulator engagement. So the operator that doesn't wait for issues before they take steps, those are operators that you will see that they have a very strong culture. So they engage regulators, they participate in industry forum, and they seek clarity proactively. So this will be the my point on what are the strong culture that they should look forward to from the operators. Thank you.
Thank you. Adetong, would you want to make comments and add to that as well?
Yes, my comment on that is that strong compliance culture should be a policy for each operators. Because when we all take it as a policy and we are focused on it, it brings credibility into the industry. Because of compliance is not to like, it's not a punishment or it's not to challenge the operators. It is to improve the integrity of the industry. So I want to say that it is something that we should all encourage. Operators should look at it for the interest of all stakeholders. That is when investors would have that confidence to come into the industry when they're sure that the compliance are well laid, policies are well laid out, and all operators are willing to voluntarily comply with all laid down procedures. Thank you.
Thank you very much, ma'am. Thank you so much, panelists. I'll just call on Mercy now to quickly take the vote of thanks as we are out of time. Thank you.
Thank you so much,
Business
everyone.
Development Representative for the Technology, Media, and Entertainment sector. So, yes.
Thank you very much, Kodichi. Good afternoon, everyone. It's been such an insightful conversation. I mean, I've been, listening from the very beginning, and it has been insightful all the way. We want to say on behalf of the firm of Jackson Edu, and particularly the sector of the technology, media, and entertainment, we want to say a big thank you and express our sincere gratitude to everyone who has made this webinar a success. Thank you so much, everyone, for attending. And our sincere appreciation also goes to all of our panelists, our distinguished panelists, for first of all making yourself available and for sharing your wealth of knowledge and the practical insights that you have also shared in this discussion. Thank you so much for thoroughly dissecting this topic and, highlighting all of the issues and the opportunities in this space. And also we want to appreciate the participants, everyone who has stayed from the very beginning up until this time. Thank you for joining us today and for the questions, engaging the questions and your contributions, the questions and the responses also of our panelists. We say thank you so much for that. We also acknowledge members of the sector who have worked very hard, tirelessly to ensure the smooth success of this webinar as well. We sincerely appreciate that. And then also, on a final note, we look forward. Our expectation is that, for all of the conversations that has happened here today, we're going to build on the ideas, build on the, the next steps going forward to see that there's so much development following this conversation. So thank you all so very much. Thank you, our panelists, Adetong, Tolu, Yeye, and Jonathan. Thank you also to our moderator, Kodichi, for taking us through this journey. It has been a very exciting one. Thank you all so much and have a very lovely day.
Thank you very much, Mercy. Yeye, our partner, Head Technology, Media, and Entertainment sector. Over to you.
I just want to say a big thank you to you, Mrs. Adeyemi, for showing up and answering all our questions in on this panel. Thank you, Jonathan, for being there on behalf of the sector, on behalf of my partners, on behalf of the whole JE. We're saying thank you very much, and thank you for making our time to be with us. And please engage us on issues. We're happy to collaborate in Lagos State, and also happy to collaborate with you, Jonathan, on issues. So please feel free to engage us, pick our brains, have our phone numbers, and we look forward to future collaborations with you as we explore the development of this gaming sector in Nigeria. Thank you, everybody.
Thank you so much. Thank you, my distinguished panelists. Thank you, everyone.
Thank you.
Bye for now.
Bye.
Do enjoy the rest of your day.